Charlie Sabatino. I am moderator for today. I am the director of the American Bar Association's Commission on Law and Aging. Good afternoon to you all. We are thrilled to be presenting a timely webinar, Free Britney, Transforming and Reforming Conservatorship and Guardianship. This webinar is sponsored by the ABA Section on Civil Rights and Social Justice, the Commission on Disability Rights, and the Commission on Law and Aging. This panel is one of many in a series of rapid response webinars. We are actively planning additional programming on a variety of issues, so please visit americanbar.org/CRSJ for updates on these programs. During today's program, we encourage you to ask questions of our panelists through the Q&A function, not the chat function, the Q&A function. If you do not see the controls, please ensure your screen is not on idle. We may try to address questions during the program as we go along. That depends upon how much I can multitask and ask questions at the same time, but we'll certainly get to them at the end of the program. And we'll be sharing a recording of this program to everyone who has registered so that you can share it widely with your networks. And with that, we're thrilled to bring you today's program entitled Free Britney, Transforming and Reforming Guardianship and Conservatorship. With me today is a terrific panel, and I'm going to introduce them kind of in the order that they appear on my screen, which may not be the order they appear in your screen. First is Zoe Brennan-Cohn. She is a staff attorney with the ACLU Disability Rights Program in San Francisco, where she's been a leading advocate, litigator, and voice for the ACLU on cases illustrating the sharp clash between guardianship and disability rights. Secondly, Professor Jasmine Harris is a professor of law at the University of Pennsylvania Carey Law School. She's an expert in disability law, anti-discrimination law, and evidence. She combines approaches in law and the humanities to better understand the role of perception, emotions, and aesthetics, the role that they play in group subordination. She writes frequently about disability and equality law for popular audiences, and her commentary appears frequently in major media outlets. Judge Lauren Holland, and each of you kind of raise your hand so that people, they have your names anyway there. Judge Holland has been a circuit court judge since 1998 in Oregon, where in addition to hearing civil and criminal cases, she presides over about 1,600 open probate court cases, 2/3 of which involve guardianships and conservatorships and other protective proceedings. Judge Holland's also a member of our ABA Commission on Law and Aging and is passionate about preserving the dignity, independence, and quality of life of vulnerable persons. Jonathan Martinez is the Senior Director for the Law and Policy for the Burton Blatt Institute at Syracuse University, where he leads its efforts to ensure that older adults and people with disabilities have access to the services and supports they need to lead independent, inclusive lives. He's probably most well known for representing Jenny Hatch in the first trial to hold that a person has the right to use supported decision-making to make her own life choices instead of being subjected to permanent plenary guardianship. Jonathan is also widely known for his prolific writing and speaking on the topic. With that, we are going to start this discussion. We hope this will be a lively, interactive discussion as we go along. We're not going to be one by one talking heads through the afternoon. What I do want to start out with is just a touch of history. Back in 1987, at one of the first congressional hearings on guardianship, Congressman Claude Pepper of Florida, then congressman, he became a senator. Claude Pepper, he was one of the most famous, if not infamous, advocates for older persons in Congress then, said this in the hearing, and I'm just slightly paraphrasing. He said, by appointing a guardian, the court entrusts to someone else the power to choose where that person will live, what medical treatment that person will get, and in rare cases, when that person will die. It is, in one short sentence, the most punitive civil penalty that can be levied against an American citizen. Well, that's a pretty bleak description. So let's start with the basics, though. Judge Holland, what is guardianship or conservatorship? How does it work?
Thank you, Charlie. Good afternoon. My name is Lauren Holland. I use the pronouns she and her. As Charlie said, I'm a circuit court judge in Oregon. I was elected to the bench in 1992, first as a district court judge, and then in 1998 as a circuit court judge, and I've been a judge since then. I'm past president of the Oregon Circuit Judges Association, and I'm also chair of the Oregon Collaborative Council of Interdisciplinary Stakeholders on Guardianships, also known as WINGS, as well as working with Charlie as a commissioner on the ABA Commission on Law and Aging. I sit on a court of general jurisdiction. I hear criminal cases, civil cases, and all of the guardianship and conservatorship cases in my court. Day in and day out, I preside over cases with people in crisis and in conflict. So let's begin with the premise that as an adult, I want to make my own decisions. As a lawyer in my own law firm in the 1970s, I expected to make my own decisions. And as a judge, I continued to expect to make my own decisions. I would have been outraged if someone else made decisions for me without consulting me, without even talking to me. Even now that I've been defined as a senior for a number of years, I still expect to make my own decisions. So what kind of decisions? Well, certainly the daily kind. When to get up, what to have for breakfast, whether to shower, when to call my children or grandchildren, whether to buy some unneeded item online. We adults make decisions all day long. And there are the more critical decisions, whether to have a medical procedure or surgery, whether to move, whether to sell my house, whether to undergo or continue chemotherapy if I have cancer. In many states, there is a presumption that an adult is competent. And if competent, we are free to make wise decisions and foolish decisions. We are free to exercise good judgment and incredibly poor judgment without anyone taking over our lives and stepping in to make decisions for us. We don't have to be smart. We don't have to know what's best for us. And even if we know, we don't have to follow that advice. Every society has its own way of caring for and serving people who cannot or who are unable to care for themselves or direct others to do so for them. So what do we do? How do we decide and how do we identify who cannot or is unable to care for themselves or their finances? That's the first question. And it is of utmost importance because if a person is able to care for themselves, has capacity, is capable of managing their finances, or has directed others to do so, then that should be the end of court involvement. So how do we maintain control over our lives without others making decisions for us, without court involvement? Well, one way involves planning. A person may appoint a healthcare representative, determine who should be their power of attorney and appoint that person for financial matters. They could create a trust and choose who they want to act as trustee of their property. A person can decide what medical treatments they do and do not want at the end of their life by signing an advance care directive. In those cases, then there may be no need for court involvement. That takes planning. That takes discussion with family and friends and other trusted people in our society. In our society, it's neither easy nor comfortable to have those discussions. I'll tell you, when I bring up this topic with my children, the first thing they will say when we talk about a healthcare representative, the first thing they say is, Mom, I don't want to talk about it. Mom, let's talk about it another time. I just don't want to deal with it. It's more challenging for us than in some other cultures, but it is a way for us to have our voices heard and our decisions honored. If a person uses support of others in making their decisions and then has the ability to make their own decision, the court may not need to be involved. We often consult others informally when we make decisions, from as simple as how do I look in these clothes or should I change my clothes to whether should I have this surgery or a particular medical treatment. In a number of states, laws have been passed that set out more formal ways of addressing this support and the relationship between the supporter and the decision maker. We're going to talk more about the benefits and the concerns of what's called supported decision making during this panel discussion. All of these alternatives have an impact on that first question. Who cannot or is unable to care for themselves or their finances or direct others to do so. Each state has laws that set out the structure and process to determine the elements that are required before a guardianship or conservatorship can be granted. Often there's three elements. Number one, is the person incapacitated? That is, unable to care for themselves, incapable of managing their finances or directing others to do so. Number two, are there less restrictive ways other than a guardianship or conservatorship available? And number three, if there aren't, is there another person who's both suitable and appropriate seeking to be appointed by the court as guardian or conservator to make decisions for the other person?
Judge, can I stop you there? Those three criteria are very important to stop and think about. I'd like to ask Professor Harris, what about this trigger of incapacity? Where does that come from? How is it defined? And is it functional?
Oh, Charlie, thank you for that question. That's a tough one, right? So the question of incapacity, let's start out by saying it's highly normative. It's highly normative, not only based on American culture, American society and traditions, but also state by state. And so it's codified into the various state statutes around guardianship or conservatorship, the way that it is often referred to. And so the notion of who's incapacitated is something that is going to vary from state to state. It's something that whether someone is deemed incapacitated because they make the wrong decision or what society deems to be the wrong decision. Let me give you an example. In some of my research, I looked at, in the context of, it's a little bit of a different context, but sexual consent, and looking at the question of when is somebody deemed incapacitated, that is to say, incapable of making those decisions. And the evidence showed that in the majority of cases, the types of evidence that was being used is evidence that we would not necessarily want to be used in those cases. For example, if they decided to have sex with someone who is of the same sex, same gender, that was deemed a symbol of incapacity. It was probative of their ability to make that decision. And so we need to really, I think, focus in on exactly that, Charlie, the definition of what incapacity means, not only as a legal matter, but as a cultural matter, because at the end of the day, it's going to wash out in terms of how it gets interpreted. Not all judges are like Judge Holland. I wish we had judges like Judge Holland to interpret it in a way that is consistent with the spirit of disability rights.
Jonathan, and I believe Zoe, you've litigated some of these cases. Jonathan, how do you see the courts dealing with the issue of incapacity?
Concerningly, there are no standards. There is a lot of presupposition. What I see a lot of is exactly what Professor Harris just said, normative measurements that don't have a lot to do with decision making. Remember, the standard for going into a guardianship is not whether you make bad decisions, but whether you are able to understand, make, and communicate decisions. And far too often what we see are IQ tests used to measure that. Now, I have to tell you, an IQ test is a horrible way to measure whether a person can make decisions. Think about every IQ test you've ever taken. You go somewhere you've never been before, sit in front of someone you've never met before, and do something you've never done before. That's not what decision-making is. Decision-making is experiential and includes making mistakes. So when we hear phrases time and again like, has the IQ of an X-year-old, it actually puts my hair on edge, because that doesn't test a person's capacity. It may test their ultimate capability, but has nothing to do with how well they make decisions. One quick example of that. The first case I litigated in this issue, the Jenny Hatch case, our expert said there was no way that Jenny could make decisions with her tested IQ at 49. The doctor then took her to lunch and said, oh, she makes her own decisions. She looked both ways before she crossed the street. She ordered lunch, she paid, she counted her change. She didn't talk to strangers. We had pleasant conversation and she took care of her hygiene. So capacity is and should be measured functionally. And that's the problem. We are seeing it based on cultural assumptions that, like Professor Harris says, are normative in nature. What should a person's IQ be? What should a person be doing? Rather, what does a person do? Or even better, what could a person do if he or she had support?
Mhm. So how does this issue of capacity fit into the broader framework of disability rights law, human rights law?
Yeah, I think I think what everyone said is really helpful and really on point about this, that this is conservatorship and guardianship are really core disability rights issues. And in disability includes people, older people who age into disability, people who have dementia, who experience other age-related disabilities, and also includes people with psychiatric disabilities and people with intellectual and developmental disabilities and many other types of disabilities. But those are common populations who end up in conservatorship and guardianship. And only people with disabilities are subjected to this kind of standard that we're talking about, where every decision you make has the potential to be used against you for the rest of your life. And we're not talking about decisions that we've criminalized. We're talking about dating someone who's a jerk. You can date someone who's a jerk and you're not perceived as disabled, and you can, maybe your mom will sort of harangue you about it now and then, but it's not going to be brought before a judge, right? And if you're perceived as having a disability and you date a jerk, that is never going to, you're never going to move past that. That's always going to be used against you if you're anywhere near the guardianship or conservatorship process. That you cannot make your own decisions because one time you dated that jerk. And there's a whole range of things like that. And that we don't, as a society, have a really robust belief in a lot of cases that people with disabilities are as complete and complex and evolving humans as non-disabled people. And that's a huge problem. And just to be really clear about, what guardianship and conservatorship is, it's a stripping of the person's civil rights and civil liberties. And I think one of the reasons that in a lot of cases people end up in guardianships and conservatorships sort of as a matter of course is that they are often perceived and thought of as a kind of a benevolent or a harmless institution. I mean, even the word guardian, right, sounds like a guardian angel. It's lovely, right? And so we think of it, many people think of it as this way to help people with disabilities. And there's some paternalism in there, and there's some, angels in there and all of that. And we need to be really clear that when you put someone under a guardianship, you're taking away their civil rights, their legal personhood, and that's a really huge imposition and should be done with extraordinary care.
Judge Holland, how does this disability bias or this paternalistic culture that we have, how do you counter that in the law and in practice? And your own experience is fine, but even more generally, do you have a sense for how it is dealt with nationally?
Well, first we have to acknowledge it. I think that's the first step, and recognize that this is something we do. Language is incredibly important. And Zoe was just talking about language. We know how important language is, the words we use, the language we use, the impact it has, the consequences it has. Each state decides what words are going to be used in the laws they pass on these issues. There is no uniformity among the states. Often states use different words, that mean the same things, or other times they'll use the same word that means different things. As an example, in Oregon, we use the word guardianship when talking about decisions about a person, their welfare, where they live, what medical treatments they are required to undergo. In the state of California, and then we use conservatorships to talk about a person's finances, their income, their property. In California, the term conservatorship is used solely to mean both. And then it's designated either as conservator of the person or conservator of the estate, meaning their finances. On the other hand, the state of Washington uses solely the term guardianship. And then once again, that's designated either as guardianship of the person or guardianship of the estate. What's also interesting is that the person who's the subject of the guardianship or conservatorship, states use a variety of terms to talk about that person. Conservatee, ward, protected person, incapacitated person, all have different inferences, different perspectives. And it's important because while the stated intention of the laws on guardianship and conservatorship is to protect persons who can't protect themselves, what's really pervasive in this system, woven into the guardianship conservatorship system, is, as was stated, paternalistic, sexist, racist, ableist, ageist, and other biases as well.
So let me ask you,
So I just want to say that it's the bias of persons with privilege and the status quo that not only do they know best for themselves, but they know what's best for others, and that others need to be taken care of, that others can't or perhaps shouldn't make their own decisions. And I think that's prevalent in the law, the practice, the outcome, and beyond. So what do we need to do? We need to recognize this. We have to confront it, and then we have to change it.
and thank you for pointing out the differing terminology, how it's kind of crazily different across states. And that also explains why for this program, when we say guardianship, we're going to use that as a generic term, and including an appointed guardian over the person or the property. And someone who is subject to a guardianship is simply that, a person subject to guardianship. But what you raised, these concerns that are raised make me think about this other concept we have in our system of law, and that's due process. Aren't there due process rights that make a difference in these situations? Professor Harris, do you want to address that?
Sure, I'm happy to. Before I do, though, I'd like to just pick up on one point that Zoe raised, and just be able to answer a question that I've seen come up, maybe not in this group so far, but what I see in the press is, why now, right? Why are we thinking about this question? And it relates to the nature of the proceedings that you're talking about, Charlie, and that everyone's been describing. There are three key reasons why I believe we're thinking about this right now. The first is the fact that this is Britney Spears, right? Let's talk about how this is about a celebrity, someone who grew up in the public eye, someone who, this is highly gendered, as Judge Holland said. We have Britney Spears, whose father, who was an estranged figure in her life prior to becoming her conservator, and yet still was appointed her conservator. This is that very gendered story about the dad coming in to swoop in and protect his young daughter who's grown up in the public eye. Let's not be mistaken here. If the gender was different, and we've seen the gender be different in different cases, like in the Charlie Sheen case, in other public cases that we've seen, you don't remember these because they're not in the media. Britney matters in the sense that it matters that it's Britney. The hashtag on Twitter, not only Britney, not just Britney, started because there are so many more people who are subject to these type of proceedings. So that's the first part. And you know, I think Zoe did a great job of talking about the sort of paternalistic system and how the very nature comes out of the parens patriae power of the state to act in the best interests. So the fact that there's this system that most people don't know about, it's been operating on autopilot because people say, oh, that's for people who are older adults or people who are severely disabled. Well, that's not necessarily true. And what we do know now, and hopefully what the public understands a little bit more, is that guardianship, conservatorship is a disability rights issue. So very quickly, I just want to pick up on the second point. Why now? Publicity. So it relates to Britney, but the system is structured in a way where historically these types of proceedings have been under lock and key. There hasn't been a lot of sunlight. And in fact, one of the first initiatives nationally that Senator Elizabeth Warren has taken is she said, let's figure out what exactly the problem is, the scope of the problem. And a lot of that has to do with the fact that it's filed under seal. There's this veil of privacy. And in my research, I talk about how privacy is often used in the disability context as a way to shield people with disabilities, but in fact, it may have the opposite effect. And that is what we are seeing in the Britney case play out live. So those are two. And so those are the three reasons I think we're thinking about this case right now. And on the due process front, I've been talking for a few minutes. I'd love for either Jonathan or Zoe or Judge Holland to jump in because I know I have been taking up some time.
Let me throw that to Zoe. Zoe, is Britney Spears' case an aberration, or is it illustrative of the norm?
I think the most unusual thing about Britney Spears' case is how much attention people are paying to it. I think that's the most unusual part of it. Of course, Britney Spears is unique. Most people under conservatorship are not as rich, are not as talented, are not as conventionally beautiful, are not as white. Like, there are unique things about Britney Spears, of course, but I think it's a really important question. In my experience, talking to people, representing people, doing research on this, reading research like Professor Harris's, is that the way the system is operating in Britney Spears' case is exactly how it operates in cases all the time. That people get into a conservatorship, a guardianship in some sort of moment of crisis, sometimes not, but you get into a conservatorship or guardianship, and then you never get out. And you can get into this real sort of like, it's almost like this kind of Alice in Wonderland sort of world where it's very hard to even get before a judge to get out. It's very hard to hire your own lawyer because you've already been found to be incapacitated. So how can you choose your own lawyer? And you're in this real sort of like, maybe Alice in Wonderland is too cute. It's like sort of Kafka-esque experience that you can really get trapped in. And we don't have the data, but we know pretty much universally from, my experience, from everyone I've spoken to who works on these issues all the time, that it's extremely hard to get out of guardianships and it's very easy to get into them.
Jonathan, was it hard for you to win the Jenny Hatch case? Were you an aberration, or are you becoming the norm?
I mean, first we need to talk about due process. And I think Zoe and Jasmine touched on it, but I think for every lawyer out there, you've got to consider exactly what we're dealing with here when we talk about failure of due process. Just as an anecdotal example from last week, I am working in a state that shall remain nameless because I haven't taken action there yet, where I looked at 34 cases over the course of 1 year in one court, 34 guardianship cases. 2/3 of them, the person was ordered into guardianship without notice, without a hearing, based on evidence submitted in the pleadings. Now, I want you to consider what that means. That means that a person's most fundamental rights, and you quoted Congressman Pepper earlier, you left out the first sentence of that quote, which is, the typical ward has fewer rights than the typical convicted felon. So with the most basic rights we have at stake, where to go, who to see, whether to work, what kind of medical care we get, and sometimes when we die, people are routinely ordered into guardianship, losing those rights without the most basic due process right we have, notice and an opportunity to be heard. And they're ordered into guardianship without admissible evidence. So that's one. And two, on the other side of that, the loss of fundamental rights and the near impossibility to regain them. Because historically, people are not given their rights back unless they prove they are, quote unquote, restored. That is the historical phrase for getting your rights back. You must prove that you were restored, i.e., cured. People with developmental disabilities don't get cured. People with Alzheimer's related dementia don't get cured. So due process is sorely lacking. As to what the norm is, I think if you are very lucky and you have a fantastic client like I had in Jenny Hatch, or you have a great lawyer like you might have in Zoe Brennan Crone, or you have a case that gets lots of attention, then the courts just may provide the due process rights that you're entitled to. But if no one's looking, then you're going in as sure as people have gone in for the last 1,500 years.
Judge Holland, I know
Ready to
I know
respond.
I don't want to put you on the hot seat, but you're the only one here who sits on these cases day after day.
Right.
How do you deal with this in your court? How do you make process due in your court?
Okay, so I do want to address due process, and I agree that due process is unbelievably critical. And I would say it rises to constitutional levels with regard to guardianships and conservatorships. We certainly, in Oregon, allow for appointment of and require appointment of an attorney if somebody can't afford to hire their own attorney, whether it's a misdemeanor that has a maximum period of 30 days in jail or an involuntary civil commitment, which has a maximum time in a locked facility of 6 months. In a guardianship, we're talking about potentially the rest of someone's life being told or forced to live in a locked facility. So I would argue and believe that this rises to constitutional levels. Due process safeguards being the right to be represented by an attorney. And I would be saying, and my proposal is that this right attaches as soon as that petition is filed. And it stays and remains with the person who's the subject of the proceedings from the moment that petition is filed through a decision that's being made. And if a guardianship is granted, for the rest of the time, the guardianship is in effect while the person is under the jurisdiction of the court. Person is entitled to notice. The person is entitled to be present at a hearing in a meaningful way. Rules of evidence need to apply, and the burden of proof needs to remain on the petitioner. That's the person who is seeking the guardianship. In Oregon, as well as in a number of other states, the burden of proof always remains on the petitioner. Now, I am aware that there are some states where the burden shifts. If a person wants to, and was mentioned earlier, if the person wants to have a restoration of their rights, modify the guardianship or terminate the guardianship, then the burden falls on that person, not by clear and convincing evidence, but in some states, a lesser burden, but a burden of by preponderance of the evidence to prove that these rights should be restored, the guardianship terminated. In Oregon, as well as in other states, the burden never shifts to the protected person. It always remains on the petitioner, who even at a termination hearing needs to be able to prove that at the present time, the person is incapacitated, that there's an appropriate person to act as their guardian, that there are no less restrictive alternatives. And it should never shift. I would urge all of us to consider that. Guardianship is not a planning tool. It's not a business model. It is not an acceptable business practice. It is a way to deal and work with and serve people only when they can't make decisions for themselves. So go ahead.
I've had the opportunity to look pretty closely at state guardianship laws, and many of them read with very strong language regarding due process rights. Why doesn't that solve the problem? Any one of you may jump in there.
Well, because judges have to interpret the language of the statute. And so you can have a statute that says, by no means should this be a first resort. And if culturally we have a system that is, as one of the questions suggests here, for some, even school districts, a first resort when someone reaches the age of majority by referral to guardianship, then we're going to be in a position where the language is not meeting the requirements, the spirit of the law is not being implemented. So that's a big piece. And then the second piece, I'm going to go back and sound like a broken record, but the publicity aspect. If we do not have that sunlight, then the accountability there is absent. And we know that accountability matters. We've seen it. That is why we're seeing such quick changes in Britney Spears's case, because you had, a million plus people break the server in California watching that live.
You mentioned school systems
Sure.
and what is often called the school to guardianship pipeline. Talk more about that. What is that all about?
Sure. And so when students are receiving special education services at times, depending on the state, they can receive services up through age 22. So after the age of majority for some students. And so when the student reaches the age of majority in the particular state, the educational rights shift from the parent or a legal guardian to the actual individual as a matter of law. And when that happens, when you reach that age of majority, when you're getting closer during the IEP meetings, some school districts have said to parents in particular, your child is reaching the age of majority. When they hit that, you're not going to be able to make decisions for them, with them. And so you need to go to the courthouse, run to probate court, and get a conservatorship or a guardianship. You need that to make the decisions. And that's just false.
Why don't courts just say no? I'm sorry, my screen is frozen, but I assume you can hear me.
I can absolutely hear. Courts don't say no for what Jonathan was saying, we were all saying before, which is that, there's if a petitioner comes to them and says, look, I'm the parent, I need to help, here's my child, they have a significant disability, then the presumption is, gosh, of course, here's this parent, or how are they going to possibly deal with banks and third parties? And so there's a lack of understanding about alternatives to guardianship. And so we see this as not the last resort, but the first resort.
Or is the only
part of what we
I think far too often it is literally the only resort. Professor Harris discussed the school to guardianship pipeline. What I can tell you is we know from national studies that the number one referral source for guardianship are schools. I was part of that published study. We asked parents and guardians what their first prompt was to seek guardianship, expecting, frankly, it would be lawyers. Number one with a bullet. Educational professionals, higher than family members, higher than friends, higher than doctors and lawyers and accountants. So there is already a push. Consider, if you are the parent of a child with disabilities, you have to be far more than a parent. You have to be an educational advocate, a medical advocate, a legal advocate. You have to know so many things. It is exhausting. So when someone you trust, like a teacher, says, you need to take this step, you need to become guardian, what is a parent to do? And then just to hit the cultural issue, why don't judges say no? Because they've always said yes. Because there's never been an impetus to say no. There's never been a consideration to say no. It's really only been in the last decade that there has been any kind of real concerted push toward alternatives like supported decision-making. The Jenny Hatch decision was 2013. In just the 8 years since then, 13 states, New Hampshire just a week and a half ago, and the District of Columbia have passed laws recognizing alternatives like supported decision-making. But that's what I mean by culture. It has taken that long for people to even think about it. And unless there is a constant push of advocacy, unless attorneys, and I'm speaking to every attorney on this call, remember, you are an attorney and counselor at law. Unless attorneys are thinking about that and properly counseling their clients, then this system is going to continue like it always has, because Newton's third law applies to law as well. The inertial system will just continue unless we take steps to push for change.
One of the things that I've noticed is that there are attorneys who often most all the petitions that I receive are asking for plenary or full authority with regard to guardianships or conservatorships. And I will tell you that most petitions do not warrant plenary authority and are not given plenary authority. And what that means is that if I establish a guardianship or conservatorship, then it has limited authority and very specific authority that is only required for the purposes of that case. I think judges need to be educated as well as lawyers who need to be educated, but it goes beyond that. It goes to educators as well as the medical profession. There is another pipeline of petitions, which is through hospitals, because there are issues with regard to discharge plans and concerns about where a person will go upon leaving a hospital, and that a facility will not accept that person without a guardianship, or at least that's what the allegations say. It's important for judges to be educated as well.
I very much agree with that, and I think that the way the process you're describing, going back to this part about due process, Judge Holland, is not what happens in a lot of courtrooms. And I think the thoughtfulness that you're describing, where somebody would seek a plenary guardianship and in fact only be granted a limited guardianship, is extraordinarily rare. We don't have data, so this is based on my experience. Nobody knows for sure, but from conversations I've had, from courts that I've observed, it doesn't always happen. And I think that's why it is really important to focus not just on reforming, on changing around the edges, on adding more due process. Those are really, really important, but we need to really systemically rethink how we treat the autonomy, the humanity of people with disabilities, and take that seriously, because there have been reform attempts and changes in law and due process changes in guardianship systems across the country for forever, probably not forever, for decades. And we still see huge numbers of people getting funneled into guardianship and conservatorship. And I think it's one of these things where if it's there, if nobody is pushing back against it, and if nobody is taking seriously that it's a big deal, that it's not going to change. And I think often one of the things that I see a lot is that, somebody was saying this before, that a parent will come in and seek guardianship or conservatorship, and a parent completely well-meaning, with the right, like everything, wanting everything that's best for their child, and in many cases having, devoted their entire lives to that. And people don't always realize that once you get into a guardianship, it's really the court has the control, not the parent. So I think there's a lot of people who get a guardianship, they're the parent, they know that they would do everything for their child, they become the guardian, and they would do it, they are doing everything for their child, but they don't realize that if they aren't able to serve in that role, if there's a dispute between them and the other parent, if they die, that then somebody else becomes the guardian. And that person might not be someone who will devote their entire lives to this, adult with disabilities. So, there are problems with guardianship. This is perhaps jumping ahead a little bit. We were, I think, without our moderator for a bit, and so we've gone rogue here, but we'll let you take us back, Charlie. But just to say briefly that there are harms of guardianship that are abuse-based, that absolutely happen, that there's real outright abuse that happens. But there's also just harm or risks inherent in the system, that having that much power is risky, that taking away rights is a harm, even if nobody ever does anything intentionally harmful, that's a really big thing to do to a person. Holding your own personhood matters, and that taking that away is a really big thing. And that people, I wish that there was more recognition, and I hope that we're moving towards having more recognition of how serious an imposition it is, and how important the alternatives are.
Are there other, sorry for the inconvenience. I've switched computers because there seems to be a technical problem with the other one. Are there other pipelines to guardianship? We see older persons being funneled into guardianship in a lot of different circumstances. How do you all see that? Any of you can jump in here.
We did talk about, through hospitals, and I think that's a major place where elders are being required to at least have a petition filed with regard to them. But I'd like to piggyback on one of the things that Zoe has said, and in terms of, I think it's more than the reform is hopefully more meaningful and different this time, because it's not just the publicity from the Britney Spears case, but we also have publicity from the pandemic, which brought to a national conversation what's going on with seniors and the just the horrific consequences to seniors of the pandemic itself, and the equity and justice reform movement, which is visible and shining spotlights on all types of systems that we have within our country. And it's the confluence, I believe, of those that are giving us an incentive, shining a spotlight on the system itself, and which may allow some meaningful change to occur.
Well, let's talk about alternatives. I don't know if you got into this while I was absent for a minute or two. But if not guardianship, then what should we be focusing on?
Well, I want to, oh, sorry. I just wanted to jump in.
Go right ahead.
I was going to jump in and say, we get this question a lot. That is to say, if not guardianship, then what? And before we go there, I think it's important to start by saying, what is the problem we're trying to solve? So even before we talk about specific reforms, due process, a civil Gideon, federal statute or federal oversight, I think we need to figure out what is that problem. And the nature of the problem has to do with what everybody's been saying, what Judge Holland said, what we started with, which is how do we offer support for people who may need support in their decision making? So I'm backing into supported decision making with that comment, but there are alternatives to guardianship. So if we flip the script, guardianship is the first order of business right now. If we make it the last resort, which, by the way, no one has said this yet, but disability rights laws and regulations require judges, it's of course at the federal level, but we're spilling over, to consider the least restrictive alternative. There's a case called Olmstead where it went up to the Supreme Court, where that case tells us and tells providers under Title II of the Americans with Disabilities Act that they have to consider the least restrictive alternatives, the most inclusive first, right? And so,
And that, by the way, is what virtually every state guardianship statute says.
Correct.
That it must be the restrictive alternative, or it must be necessary because there are no other ways of dealing with this person's situation. But that doesn't work.
That doesn't work. But I think understanding that this is part and parcel of a larger conversation about disability rights law is important. So as we have lawyers on this call, it's really important to see this as an Olmstead enforcement issue, right? This is about Olmstead enforcement. So what are the alternatives? I mean, Jonathan, you've been working on supported decision-making for a long time. And so I'd love for Jonathan to talk about supported decision-making.
And thank you, Professor Harris. I want to start with, without being offensive, saying, Charlie, I think you've asked the wrong question. The question should never be, if not guardianship, what? Because that assumes that guardianship is the primary and everything else is an alternative. Erica Wood, who used to work for the ABA, used to get all over me when I used the phrase alternatives to guardianship, because that assumes guardianship's the norm. She preferred the phrase options, because there are many options, one of which is guardianship. On the other end of the spectrum is no guardianship and no other supports. So I would suggest the question we should be asking, the thing that we should be looking for, is how do we maximize self-determination? Forgive me for getting into the weeds, but here is something that we know. We know from 40 years of studies that for people with intellectual and developmental disabilities, and older adults. Those who have more self-determination, those who have more control over their lives, those who make more decisions in their lives, have demonstrably, measurably better lives. For people with intellectual developmental disabilities, for example, we have 40 years of studies saying that they, when they have more self-determination, are more likely to be independent, employed, healthier, and safer. For older adults, those with more self-determination are more independent, better able to take part in their healthcare decisions, and better able to adjust to increasing healthcare needs. So exactly the things that we want, not just for the people in our lives, but for ourselves, are directly correlated to self-determination. So that should be the first question we ask. How do we maximize self-determination? Because that also feeds in legally, because the least restrictive and alternative is the one that maximizes decision-making opportunities or self-determination, which can lead us into a bevy of alternatives, one of which is supported decision-making. We should never be saying there's only one option or do this first or this second, because each and every one of us is different. So very briefly, supported decision-making is this. It's what you do every time you don't know the answer to something. Every time you ask a colleague for advice, every time you ask a doctor to explain something in plain language, every time you ask the auto mechanic to explain something to you in a way that you'll understand, every time you do research, you are engaging in supported decision-making, because by definition, supported decision-making is getting the help you need to understand and make the choices you need to make so that you can make and communicate your choices. It is something each and every one of us does each and every day, with one difference. If you are a person without disabilities, a temporarily able-bodied person, because we are all 1 second away from having disabilities, when you use supported decision-making, you're being smart. You are making an informed choice. You are not going off half-cocked. You are not making a snap decision. You are getting a second opinion. You are measuring twice, so you only have to cut once. But if you are a person with disabilities, if you dare say, I don't understand, can you explain it to me? Then historically and culturally, what we assume is that person is incapable of making decisions. So getting back to my original point, the question we should be asking is not, what can this person not do and what else can we do besides guardianship? The question we ought to be asking is, what could this person do if he or she had supports and services, and how do we incorporate those to maximize that person's self-determination? Because science and law say that's exactly what we should do.
Jonathan, how do we create those supports and services if they aren't naturally there in a person's life?
There are just so many supports and services that are available right now that aren't being fully utilized. One of the great ironies that we are facing right now is we have more ways to make more people more independent than ever before. Consider the phones that I hope you're not looking at right now. If you spend more time using your phone as a support device than you do as a phone, with my phone, I can speak with my doctor and loop in someone to help me understand the doctor and the doctor understand me. With my phone, I can give someone access, if I choose, to my bank records to help me budget. With my phone, I can set reminders so I take my medication, reminders so I make my appointments. The great irony is that with all that technology available, with programs like Medicaid waivers and vocational rehabilitation and centers for independent living and special education supports and services, with all of those, the number of people going into guardianship has tripled in just the last 25 years. So Charlie, again, I don't think the question is how do we create the supports and services? I think the question is how do we best ensure that the supports and services that already exist are properly utilized? And that is on each and every one of us. Remember, we are attorneys and counselors at law. We must be aware of these things and counsel our clients accordingly.
Very good points. Very good points. You also mentioned the numbers of people going into guardianship. Do we really know any of the numbers with any certainty?
No. There are numbers like 1.5 million adults nationwide being thrown around that come from a study that is quite dated now, but we don't know. There's no requirement that every state produce this data, and so we really have no idea. But in some ways, the actual number doesn't matter because we know the system is problematic. Yes, it'll bolster our case, but it is a problematic system. It's systemic, as Zoe says. And so now what we should be focused on is, yes, we should have the accountability and the sunlight moving forward, but we ought to start putting into place really the types of supports that Jonathan is mentioning here.
And
One
just,
of the,
I was just going to just piggyback on what Jasmine is just saying, that yes, I think one of the most striking things about the fact that we don't know, we don't have data, is that we count what matters to us. We have data on what we as a society consider important, consider risky. We have a lot of data, for example, on the numbers of people in jails and prisons, because a lot of advocates for reform, for abolition, focus on that data, because that's data that we need to know, because it's a big deal to put someone in jail or prison. We have data on healthcare issues that we consider important. We count what matters. And I think it's really striking and not a coincidence that we do not count how many disabled people's rights have been stripped from them, or for how long, or under what circumstances. And we absolutely need to fix that. We need that data, but it's not a panacea. Having the data, I think, has to be part of the system of taking this really seriously and recognizing that guardianship and conservatorship is a really big deal, and we should know exactly what's going on with it.
But we do have good data on one thing. We have data on the import of people's lives being better when they don't experience guardianship. I recommend that any and all of you look at the National Core Indicator study, the last two. The NCI was a national study looking at the quality of life of individuals with intellectual and developmental disabilities. It was, as a non-scientist, what I call an apples to apples study. It compared the quality of life of people with mild disabilities to mild disabilities, moderate to moderate, severe, severe. What it looked at was the impact of certain variables on quality of life. Just one of those variables was whether or not a person was in a guardianship. And across the country, what the last two National Core Indicator studies have found is this: those who are not in guardianship are more likely to live independently, be employed, have their rights respected, have friends, socialize in their community, get married, and practice the religion of their choice than similarly situated people who are in guardianship. So the important data is there. It is on us to make it useful.
I think there's other important data as well. And I think one of the things that was being said was we measure things that are important to us. It's not only in Oregon, but we have begun measuring and collecting data. What we are trying to do is relevant data. We have approximately 14,500 open guardianship and conservatorship cases in our state. And then we go from there. So we're starting to measure. Why is that important? Not only because it reflects what's important to all of us, it also allows us to go to the legislature and be able to have a basis upon which to seek funding or resources for oversight, for monitoring, for accountability, to ensure that when we have jurisdiction over people's lives as well as over their property, that we can take the steps that we need to do to hold people accountable, the people who are making decisions, as well as to protect those persons who happen to be under the jurisdiction of the court. You know, there was a participant that said that I'd like to address. One of the reasons that they're concerned about guardianships and conservatorships is the profitability of this to attorneys and to guardians, whether they're professional or sometimes family members as well. And I think that's really important. What is amazing is that under many states' laws, it is the protected person, the person under the guardianship or conservatorship, that has to pay for not only their attorney, but for the petitioner's time, the guardian's time, the guardian's attorney's time as well. And courts do not have the ability, and I think it would make a big difference if courts had the ability to require the petitioner or the guardian to pay for their own attorney or to pay for their own expenses when those things arose. And one of the areas of reform that we're looking at is trying to ensure that the courts have the ability to have attorney fees assessed against the people who are trying to get the guardianship or conservatorship, not placing the entire burden, as it always has been, on the protected person. And I think it's really important to look at that as well.
Let me add one more point, which is why the data matters. The data is going to allow us to see disparate impact. And we know it's there. And disparate impacts along the lines of gender, which I've already mentioned, but race, ethnicity, class, all of these factors are critical to understand. And we know that this data works when you do a data collection, like the civil rights data collection in the education context. When they started to disaggregate the numbers around school suspensions and school expulsions, that's when we began to see the disparate impact, where it was clear that there were students of color being disproportionately affected. Well, given that there is a school to guardianship pipeline, this is critical for us to understand, and we don't yet understand. And so I just, again, being the data privacy publicity person here, I'm pushing on all fronts for the data.
And with respect to that data, one of the interesting things, Jonathan mentioned the National Core Indicators. The National Council on Disability looked at that data, and they were able to look at the percentage of persons with intellectual disabilities or developmental disabilities under guardianship across the states, most of the states, over a 10-year period. And the average percentage was between 45 and 55% over that 10-year period, although it varied with some states up in the 80% and some states in the teens. But how do you explain such a huge variation in the data when we simply don't know more?
Charlie, do you mean in terms of I know the statistic you're referring to, you mean in terms of disparate impact?
Well, it certainly relates to that. That's a very high percentage of people in a particular group being singled out.
Right. Again, we have to think about the sources of these pipelines and these institutions that are funneling individuals into the guardianship system. And it's public hospitals, right? It's nursing homes and places of care that are often utilized by people who are Medicaid recipients. So if you look at the data, the underlying data in terms of like what are the sources, then you can explain some of the disparate impact. Again, we're talking about a system that really has not been on people's radar for that reason. It's not been on people's radar because we're not talking about Britney Spears. If every person under guardianship and conservatorship was a Britney Spears, this system would have really been dismantled a long time ago.
Well, let's talk about change and dismantling and some solutions. We've talked about supported decision-making being an underutilized and important framework for giving people supports. Judge Holland mentioned one aspect of law that who pays for proceeding in a guardianship case, who foots the bill, something that deserves considering change. What are the key kinds of changes we should be looking at, and are they all legal? Because isn't there a connection between law and culture here? It seems to have come up many times during this conversation.
Well, a year ago, August of last year, the ABA adopted a resolution urging Congress to create and fund a guardianship court improvement program, similar to what occurred in the 1990s with the child welfare reform court improvement program. What that did for child welfare and the court was to raise the stature of juvenile courts and juvenile dependency courts allow there to be a lot more scrutiny. And as a result of that court improvement program, there were a lot better outcomes for children and for families. We're looking at a guardianship court improvement program in May of this year. The National Guardianship Network, which I think many of you know is a collaborative group of national organizations that are looking at effective guardianship law and practice, convened a National Guardianship Summit, which occurs once every 10 years. And a number of people who are on this panel, we participated in that. There were 125 advocates in May of this year meeting in this summit of advocates, family guardians, judges, lawyers, other stakeholders in this 4th National Guardianship Summit. And as a result of the work done in the summit, there were 22 recommendations to improve and reform the adult guardianship system, including, and you can get these and access these online. They're easy to access, and there's been some publicity about it. It happened this summer. One of which was to recommend to Congress to establish a guardianship court improvement program, which would be based on the successful model of the child reform court improvement program. What it's supposed to be doing is providing national funding and infrastructure, which is something that's needed for technical assistance, which was also something that was mentioned, in order to get meaningful data collection, to improve court oversight and conservator and guardian accountability, to work on avoiding unnecessary guardians and overbroad guardianships, and to work on collaboration of all of the stakeholders and education of all of the stakeholders. Then the state courts would be required under scrutiny as well, which is what needs to continue, is to have continued scrutiny, to have authentic improvement. I'm not a unique judge. I am not unique in this field, that most judges are as conscientious and attempting to follow what the law is. This will involve reform of some of the definitions, even of what is incapacity, because it is a vague definition. If you go to each of these states, subject absolutely to interpretation and subject to all of the unconscious biases that we work on and live upon unless we educate ourselves and work hard to change. But this is the time to make it happen. And I think it's that's
One of the recommendations of that summit, by the way, was to eliminate plenary guardianships altogether. What do panelists think of that?
I can jump in on that. I was on the subcommittee of the summit that recommended that, and I think that's a really exciting recommendation, to have plenary guardianships meaningfully be not available unless you can prove that there are particular reasons for each of these things, that a person only loses their rights where there's real proof that the person absolutely must. And that's not the end goal. My end goal, my vision of the world, and I think this is true of many people in the disability rights space, is not 1.5 million limited guardianships, whereas now we have 1.5 million plenary guardianships, if that's the number. Like, I think all of these changes need to be with a very clear goal in mind of far, far, far fewer people under guardianship and conservatorship. And I want to be clear that there are really hard cases, and I don't want to deny that. There are people who are deeply isolated and have really significant, really complex disabilities, and don't have support systems. And it's really hard to know what a person wants. It's really hard to put into place what, a supported decision-making arrangement. There's no question that there are really difficult cases, but there are also many, many cases that could, with a judge who asked a serious question. If when you petition for guardianship, and if the judge said, "Why are you here? What's the problem you're trying to solve?" And if the answer is, there's no problem. My kid just turned 18 and the school told me to do this. The judge should say no. And it's very rare that you hear about that. So I think there are, there are a lot of ways to get at that, and changes in the system, in due process, changes about what the responsibility of the lawyer is. If you have a lawyer, in a lot of cases, lawyers sort of, in cases where their client is disabled, sort of smush together what the lawyer perceives as the person's best interest and what their client actually says. And that doesn't happen outside of the context of having a child as a client or a disabled person as a client. If you're a criminal public defender, any criminal defense lawyer, and your client refuses a great plea deal, they can do that. You don't go telling the judge, well, I think she should have taken the deal, but she doesn't want to. You advocate zealously for what your client says they want. And there should be much more, like that needs to be much more clearly required and done in practice when people do have lawyers. So there's a lot of ways to get at it, but I feel very strongly that what the changes have to be driving towards is a really dramatically reduced number of people in guardianship and conservatorship, period.
Mm-hmm.
Right. And just also to say what the source of that is too, what Zoe's saying, there's a model rule of professional responsibility 1.14 that says that you should in fact represent what your client wants, even when they have diminished capacity. And so there is a rule there that guides what we do as lawyers. And the other point I wanted to make is that this notion of reform, Charlie, that you're mentioning, it's also coming, it's not, and it shouldn't be lawyer dictated, right? It should come from the individuals with disabilities themselves who have been advocating for changes to guardianship forever. Or I know Zoe said maybe not forever, but for years, right? And so this moment is also the product, and I would be remiss if I didn't say it, the product of advocacy by people with disabilities, self-advocate groups who've been working to get us to this point. And we should continue to engage with disability rights groups and have people speak for what they do want. And the qualitative studies have shown that people with disabilities want to retain autonomy whenever possible.
And it's incredibly important to point out that whatever reform takes place can't just be legal or law-based. I know it's hard to say this to a room full of lawyers, but laws alone don't solve problems. If they did, there would be no discrimination based on race or gender because the Civil Rights Act of 1964 took care of that. How's that going? What we need is a broad-based educational and advocacy-based reform so that more people are aware of more options. More people want to pursue those options. The younger parents that I speak with are always the ones who I'm seeing want more independence for their children. The younger advocates want more independence for themselves. It's reaching out beyond the obvious. It's not just talking to lawyers, even though I keep saying we're attorneys and counselors at law. It's reaching out to the teachers. It's reaching out to the doctors. It's reaching out to the accountants, all of those drivers of guardianship and conservatorship to say there is a better way. And last point, Professor Harris is right. Rule 1.14, some version of which exists in almost every state, I think 45 states, goes beyond talking about your client's interests. It requires lawyers to use supported decision-making because it says that lawyers must maintain a normal client-lawyer relationship, even when their clients have diminished capacity. Client-lawyer relationship is defined in the comments as understanding that even with diminished capacity, many, if not most clients are capable of making decisions when properly informed. That is just the definition of supported decision-making. So lawyers are not the only source, but can be a leading source. People with disabilities should be the leading source as we look for multiple paths to reform to get to where Zoe says correctly we need to be.
Exactly. Although changing the law is not going to change, it's not going to solve the problem. I totally agree with you 100% there, Jonathan. But there are things that the law needs to change. And one of them, many of them have been put into models such as the Uniform Guardianship and Conservatorship and Protective Proceedings Act, which includes options such as single transaction orders as protective orders rather than use of guardianship. And Judge Holland, I know you have experience in using that. Does that make a difference?
It does make a difference. It makes a big difference to allow the flexibility to fashion whatever order needs to occur, if an order needs to occur in the first place, for a specific event, and then it's over, and then the proceeding is terminated. I think that is really important. I think that something Jonathan said resonated in terms of the attorneys. I think actually all of the other panelists were talking about attorneys and how they interact with their clients if the client is the subject of these proceedings. Because whether it needs to be as part of continuing legal education for new lawyers and then continuing legal education on a yearly basis, there are numerous cases where I have talked to attorneys about their ethical responsibilities in terms of their client, and that they are not there as what do I believe is in the best interest of my client. They are there to represent the position of their client. They are advocates for their client because that's the only voice at times that clients have in order to be able to present what their position is. And when the attorneys start to become themselves best interests or the paternalistic actions that are done, then everything is the system, it breaks down in that way as well. And that's an important piece. It's from every aspect. It's from the medical doctor who is making end of life decisions as opposed to talking with the patient as to how they want to see their lives ended and what treatments that they want to engage in and don't want to engage in, to disputes between family members, because they are complex cases and they are complex and challenging and oftentimes dysfunctional family dynamics that we're dealing with, in addition to all types of government regulations who have their own rules that have to be followed in making decisions about whether or not the burden of proof is met. I only want to get back to that because I think that it's not just deciding what's best for this person. There's a burden of proof, and a judge is required and continues to be educated and needs to be educated that if the burden of proof isn't met, then it's a denial of the petition. Clear and simple. That if somebody is found to be proven incapacitated and there is no less restrictive alternative, but the proposed guardian is not appropriate, then the three elements have not been met and the guardianship has to be denied. It has to work that way.
Thank you. I'm getting conscious of time, and I have a technical disability of my own here, and that I'm using my cell phone and I cannot easily practically switch over to the chat. So I'm going to ask Professor Harris if you wouldn't mind scanning not the chat, the Q&A function, and identify any question you think is worth bringing up at this point in our last several minutes of the session. While you're looking at those, I will ask one question though. We've talked about the role of the lawyer, but what is the role of the guardian? There are guardians getting appointed today, and they're going to keep getting appointed. How do we define the role of the guardian? What should it be? Shouldn't supported decision-making be just as much a function of the guardian's responsibility, Jonathan?
Yes, absolutely yes. Almost every state has a law saying the obligation of the guardian is to maximize the independence and self-determination of the quote-unquote ward. The way I see that is the guardian's job is to work with the person, to help that person either regain or gain or obtain the ability to make decisions and direct his or her own life. In other words, the guardian's job is, whenever possible, to put him or herself out of a job. And the laws are very clear on that. And I will tell you, I have seen judges really happy in 3 situations: adoptions, citizenship ceremonies, and guardianship terminations. Because in each, the judge is saying and taking part in a process to create a family or a citizen or an independent being. So it is and should be the guardian's ethical job, according to the National Guardianship Association, and legal responsibility, according to just about every state law, to empower the person, not restrict them, to engage with the person, to, as the judge said in the Jenny Hatch case, to help the person make the decisions he or she would and wants to make, rather than doing what he or she thinks is just best for that person. If we were to go there, then you would have very few bigger fans of guardianship than me, because the point is to empower and then to help the person progress, only when needed and only in those areas that are needed. Unfortunately, we're not there, but I think it was an incredible responsibility, and thank you for bringing that up.
I'm going to jump in with the homework that Charlie gave me. So I scanned the questions, and I have to say thank you to everyone for participating and being so active in this discussion. It has just been a pleasure to see your questions and to see how engaged you've been. So there's no, all the questions are worthy. I will ask 3 and then throw it out and see if people have final thoughts on these 3 questions, which are in the latter part. The first is one person asks, is there a way to file an ethics complaint against a lawyer that pushes for guardianship? And that may not, to paraphrase these questions, may not be using the continuum that we've been talking about in terms of guardianship as the last resort. The second question, actually I'll ask 2 because I'm looking at the time. And the second is a question that provides more of a fact pattern here. How would we think about an individual, an adult who's 42 years old with Asperger's, autism diagnosis, with a high IQ, but has poor decision-making issues related to an OCD, without giving legal advice here, using this as a hypothetical, how do we think about guardianship in the context of people who need additional support, such as in the fact pattern that I just gave?
With regard to that, we do and should be thinking about what supports the person needs. I'm not dodging the question when I say I never tell people what to do with regard to whether or not they should seek guardianship. I don't know them. I don't know the person in question. To whoever asked that question, I'd be very happy to speak with you and get more details and maybe give some advice. But the thing is this, where we should start is with maximizing self-determination, however that can be done. So we think about, first and foremost, what that person needs to be able to make decisions in the best possible way for that person, not the best objective decision, because that's not the standard, but to be able to understand, make, and communicate those decisions. And then we see how that person wants to be helped, how that person wants to be helped, starting with the person, what kind of help the person wants, and who that person wants help from. If we start there, then we can identify areas where supports are needed and what support should be provided. And then we can get a good long way down the road to figuring out what we should do next.
Anybody want to respond to the ethics question?
I'd be glad to. Every state has a bar association, and anyone is always entitled to discuss or to call or to complain about what they perceive as an ethics violation to the bar, because they are the regulatory body for lawyers. I think judges also have a responsibility if we see what we believe may be an ethical conflict or an ethical question, to raise the question and to do it on the record, so that it is clear that there may be an ethical issue. But anyone is entitled to contact the state bar organization that regulates lawyers when there's concern about ethics being and professional responsibility rules being followed.
Isn't there
Oh.
a problem though with Rule 114 itself? I know it was mentioned that it requires you to maintain a normal lawyer-client relationship, and that means that the client is the ultimate decision maker. But then it turns around and says if your client has diminished capacity and is in harm's way potentially, that you have discretion to take protective action, even to the point of filing for guardianship in at least a number of states. Isn't it? We have kind of a mixed message there, don't we?
It is a mixed message, but there's also, it's similar to the mixed message with regard to what's the standard of decision-making for guardians. There is something called substitute decision-making, and it's a confusing name, but the standard of substitute decision-making is what would the person under the guardianship do if they were able to make their own decision, which means that the guardian is required to either know or get to know the person under the guardianship, to learn their history, their preferences, their values, their needs, what they would do. It's not a matter of what's in the best interest of the person. And I think there's that dichotomy as well with the lawyer's ethical obligation, but it still doesn't allow the lawyer to then replace what the client wants to do and has their position with their own. There are certain steps that they can take, but that's different and distinct from, in a court proceeding, assuming a position that the client is opposed to.
Charlie, two quick points to follow up on the ethics question. The first is, again, going back to this, the privacy and publicity notion here, which is if we had a sense of the transcripts from these proceedings, if we understood the facts of these cases, if we had these documents in the public domain and these proceedings themselves open, again, subject to certain restrictions. I'm not here advocating for a blanket open policy, but we know how to do this in a nuanced way. If we had that, we could also see trends over time, making a case, making an ethics-based case. That is all easier when we have the sunlight showing. And then the second point I wanted to raise here is, and it comes from the questions. And the question had to do with, well, how do we think about this? Sometimes judges are more inclined to appoint a guardian where you have someone with communication deficits, or rather disabilities around communication. And that's certainly something that we do see in the research to the extent that we have public data available. But the notion of someone with communication support needs needing a guardian just is a fundamental misunderstanding of what it means to not have normative communication, right? If you have a non-normative form of communication, suddenly that is seen as deviant, a deficit. And so that's the education and the culture that Jonathan and so many of us have been really trying to hit home during this conversation.
Okay. Giving you each 30 seconds to give us what people should be doing or thinking about tomorrow. Go ahead, Jasmine. You're up.
30 seconds, giving a law professor 30 seconds. Okay, I'm down to 10. I think what needs to happen is people need to start to reflect on the connections we've talked about and how this is bigger than Britney Spears, and this is a disability rights issue. And so that would be my take home.
Zoe, what should we be doing or thinking about tomorrow?
What Jasmine said, I'd also suggest finding disability rights advocates and disabled people on social media to follow. There's just so much to learn from Twitter. There's nonsense on Twitter too, but there's just it's just an amazing resource, and other social media too, to just think about this work and hear the perspectives of folks who are directly impacted by this, who are themselves disabled.
Judge Holland, your take.
I think we need to reflect on ourselves and how what we bring and the biases that we bring to the table every time we either hear a case, take on a case, learn about a case, and how we need to ensure that the steps that we take enhance people's lives and independence and autonomy, not take away from that.
Great. Jonathan, you have the last word.
Keep in the front of your mind, everyone, that we can do better and we have to do better. The reforms that we're talking about, the changes that we're talking about impact every single person in our lives, and just as importantly, impact us. Because unless you are lucky enough to die suddenly, then someday you are going to be the person, aged, infirm, have a disability in the system. And what kind of system do you want when it comes your time? And if you want the kind of system that respects and protects your rights, then keep at the front of your mind this sentence: we can do better. And then do what we have to do to make it better.
Thank you all, and thank you all for joining us for this free webinar. I'd like to express our gratitude to this esteemed group of panelists. For starters, you're doing such critical work, and we thank you for being out there and taking the time out of your schedule to share your experiences today. The section on civil rights and social justice provides free webinars and resources for legal professionals and advocates nationwide. We hope this helps you in your work. And again, if you can, please consider joining and becoming active in the ABA. You may do so at ambar.org/CRSJ. Best of luck in your work. And